Hello, everyone, and thank you so much for joining me on this Saturday. I'm going to make sure that we are streaming on Facebook, Twitter, and YouTube just real quick before we get started. Please, comment, where you're watching from as I make sure that we are streaming on all the platforms. This is my only second time doing this on StreamYard, so bear with me, but I think I'm starting to get the hang of it. So let me make sure. Okay, I think we are good to go. All right. Well, welcome everyone. And I am going to be speaking about some of the defense's motions to exclude some evidence from the trial. Of course, the judge will make the final say in that, but as we wait for more people to join, we are less than 2 weeks away from Barry Morphew's trial for the alleged murder of Suzanne Morphew. Jury selection could take a few days before opening statements begin in early May. Those juror members have already received their jury summons, and I bet a lot of the witnesses in the case have already been contacted as well. Many people are expected to travel to Canyon City to watch the trial. It won't be broadcasted, and as of right now, still no live tweeting or computers allowed in the courtroom. It's a case where we still don't know where Suzanne is. So let's recap while we wait for more people to join this live stream. Mr. Morphew pled on a video published on Facebook just 1 week after Suzanne disappeared for whoever had Suzanne to bring her back home safely. Do you remember that? There was also a reward for $200,000 for safe return, no questions asked. I'm not sure if that reward is still offered or not right now. Now Barry Morphew he's maintained his innocence since day one. There was a large search by Suzanne's brother, Andy Mormon, but Mr. Morphew didn't participate, and that was around September. When I asked Morphew prior to if he was going to, he told me he was, but he also mentioned that he thought it was a publicity stunt that Suzanne's brother was doing. On May 5th, nearly a year after Suzanne disappeared, he was arrested and charged with the first-degree murder, tampering with deceased body, tampering with physical evidence, possession of a dangerous weapon. It was a short rifle, attempt to influence a public servant, forgery of public records, and a misdemeanor ballot offense. Now, those last two charges, as well as the possession of a dangerous weapon, have been severed from the murder case, meaning that those will be tried after the murder trial. He spent about 5 months in jail until the judge at the time issued him bail after the preliminary hearing. He was able to bond out of jail for a cash bond of $500,000. The original judge, Patrick Murphy, recused himself due to a family friend whose law office was representing a potential witness, Shoshona Darkey, who is reportedly Morphew's now girlfriend. And now Judge Ramsey Lama is at the bench. The case has been moved from Chaffee County to Fremont County. It's just one county over, and it is staying in the 11th Judicial District. If you missed my last video, which was on Thursday, please go back and watch it. I explained through new court documents how investigators and prosecutors excluded all 3 CODIS partial DNA matches from Suzanne's Range Rover glove box that had been linked to sexual assault cases in other states, which is a huge reason why Morphew was allowed bond. And it's also the defense was weighing heavily. It was a defense for them. It weighed heavily for their client. I also spoke briefly about the prosecution's wishes to exclude a handful of defense expert witnesses. Yes, I am still trying to put together all the documents in an article. I do still have a full-time job, and I currently am working that today. I will be on Fox 21 News tonight at 9. Again, if you haven't watched it, please go back and watch that video from Thursday. So, but today let's check out what Mr. Morphew and his all-women defense counsel wish to exclude from the trial, which is set to begin April 28th. Before I do, please be kind to one another. Your discussions in the chats, no bullying, no bashing, no trolling. You can all share different points of views. You don't have to agree, and just please, please, please be respectful. You got to remember that the prosecution must prove that Barry Morphew is guilty of committing murder in the first degree, not that Suzanne did or didn't leave her girls on her own. The defense does not have to prove what happened to Suzanne. The prosecution has the burden of proof for the trial. So I'm going to talk about some motions. They're called motion in limine. It is to prevent mention of the information in remarks or questions in front of prospective jurors. If that makes sense. Okay, so I'm going to share my screen. This is why I got StreamYard, so I could do that. Make sure. Okay. Okay. We're going to look at defense's motion 78 first. Trying to get it bigger for everyone. Okay, so this was filed April 5th, and this is motion in limine to exclude evidence, testimony, arguments, and comments about a needle sheath cover, the darts, Marlin dart rifle, and animal tranquilizers. So Mr. Morphew requests an order to exclude any testimony, photographs, or other evidence and or arguments regarding a needle sheath found in Mr. Morphew's dryer several days after Suzanne Morphew went missing, and other items mentioned in the arrest warrant affidavit. Let me see if I can pull up the actual book that they found in the safe in the garage, and a dart box. One dart was found under the bench in the garage as well. So all of this evidence, the defense does not want to include in the trial. They would like to have the judge exclude it. It says this court should prohibit not only direct evidence, but any indirect evidence, comments by others, including Morphew, when questioned about the sheath darts or animal tranquilizers. So they don't even want comments that he made to investigators about this evidence. So anytime he talked about the dart or the sheath cap or the any dart material or even the dart rifle, they do not want that in the trial. So what they're saying as far as why they think it should not be allowed is rules of evidence, Colorado. Let me make sure I say this right. The objection is based on rules of evidence, Colorado rules of evidence, 401, 402, 403, 404, and 608. 401 is the definition of relevant evidence. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And Rule 402 is relevant evidence generally admissible. 403 is exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. Rule 404 is character evidence, other crimes, wrongs, or acts. And Rule 608 is evidence of character and conduct of witness. So again, the defense does not want evidence, testimony, arguments, and comments about the needle sheath cover that was found in the Morphew's dryer, darts, the Marlin dart rifle, and animal tranquilizers. This is motion D78. Let me see if I can pull up. Okay, let me see if I can pull up the actual, what they look like before we move on to the next motion. Bear with me. Share screen. Okay. Oh, that's not what I want. Oh, sorry, guys. Okay, here it is. Sorry. Okay, so this is the dart book that was found in the garage. And then this is the garage itself. And then this right here, if you, I don't know if you, yeah, you can see my hand, the scroll. That's the needle sheath cap found in the dryer right there. And then these are some of the tranquilizer material boxes. That's the gun safe, or the safe in the garage that the book was found in. I believe that's the book, or maybe the dart box right there. I don't know if you can see my scrolling. And then that's the dryer, the Morphew dryer with the clothes that were in it, and the sheets as well. And then here's what it looks like, a needle with the sheath cap on it. Like it hasn't even been opened, this one. And then here's a comparison to the cap that they found in the dryer to the one that was unused. Again, just a different one inside and here's the actual one that was found in the Morphew dryer. Looks like it was a tranquilizer material box. And here's some more pictures of inside of the guidebook, the dart guidebook. So the defense doesn't want any of this included in the trial. Okay, so I went through all the photos. Let me go back to the documents. Bear with me, I'm sorry. Okay. All right, so this is still the motion to exclude the dart material, as well as any testimony, comments about the dart material, the animal tranquilizer material, or the darts as well. The prosecution has set forth a speculative hypothesis that Miss Morphew was killed and that the method of the killing has something to do with administration of an animal tranquilizer. In support of this speculative theory, the prosecution speculates that it is relevant that a needle sheath that was found in the dryer of the Morphew home more than a week after she went missing and in the garage were found the dart book from the safe in the garage, one dart from box under the bench in the garage, and other items. Also found in the gun safe was the Marlin Dart rifle, the tranquilizer serum, vials. Remnants of such were not found on Mr. Morphew or in or around the home or any of Morphew vehicles. The prosecution's speculative theory appears to be that the sheath, or perhaps the garage items, housed a drug that Barry Morphew forcibly administered upon Suzanne. On March 30th, 2022, DA Holbert claims the needle sheath was relevant due to DNA on the sheath. The DA stated that even though Barry Morphew's DNA was not found on the needle sheath, it was relevant because Suzanne Morphew's DNA was found on the needle sheath. This is false, according to the defense. The DNA report generated by DNA expert Rogers and provided by the prosecution states that the partial DNA mixture is indicative of two contributors developed from the swab of the needle sheath, and that the mixture is approximately equally likely to be observed if it originated from Suzanne Morphew and an unknown, unrelated individual than if it originated from two unknown, unrelated individuals. Likely ratios 1.7. The analysis is uninformative due to the approximately equal support for the two propositions. So the prosecution's DNA expert Rogers will not stretch the bounds of science and or ethics to conform with the prosecution's claims and testify contrary to the results obtained that Suzanne Morphew's DNA was on the needle sheath. Additionally, while the DA asserts that DNA is relevant, the DNA results from the body of a dart seized from the garage excluded Barry Morphew as contributors. And in parentheses, they have and Suzanne Morphew. Discovery page, and then they list the number. And as for the box, the swabs from the box were not suitable for DNA comparison as the number of contributors could not be reliably determined. Anyway, so they just do not want the needle sheath, the dart, any conversations that Barry Morphew had with investigators about animal tranquilizing or needle cap, the needle sheath cap, or dart material or the dart book admitted into trial. They do not want the jurors to hear this information. If you want to read on, I kind of will scroll a little bit more. Mr. Morphew was questioned by law enforcement about the fact that in the past he obtained prescriptions and then utilized them on animals when he owned a deer farm in Indiana. And then because no tranquilizer serum was seized in this case, 11 months after Miss Morphew went missing, law enforcement provided Mr. Morphew a string of hypothetical regarding the existence of tranquilizers. Again, this is information from the defense. Then he was asked if he had some left. He was asked where could they have been. Then he was asked if they were on his workbench and could he possibly inadvertently thrown them away when he was going to Broomfield. And when Mr. Morphew was talking to investigators, he did admit one of his trash runs that he me. Oh, we're back. Sorry. Okay. The Marlin Dart rifle that was found in the gun safe. It's been mentioned many times in court that it was inoperable or it hadn't been working or it hadn't been used in a while. So these are kind of reasons why the defense believes that this evidence should not be included in the trial. Such evidence is irrelevant because there's no proof that they are connected to Suzanne Morphew's disappearance. There's no proof that the proposed evidence is connected to any particular drug, for example, an animal tranquilizer, and in the exhaustive search, no tranquilizer serum was obtained by law enforcement Conversely, it has been determined that the DNA of various items does not support Mr. Morphew's use of darts or serum prior to Miss Morphew's disappearance, and the Marlin dart rifle was not in operable state. Was not in an operable state when the Morphew house was seized. The murder of Miss Morphew, they don't even have proof she is deceased, and no articulable theory about whether she was killed, how she was killed, and how her body was disposed of without leaving a trace. The court did deny requests to call a veterinarian to testify about BAM, which is an animal tranquilizer, which is mostly used on deer. This court stated that it was not at the time ruling one way or the other on admission of the needle sheath or cap found in the dryer of the Morphew home. So at the time, the judge said, I'm not going to make a decision whether or not the needle sheath cap will be admitted into evidence for the trial. Again, the court had mentioned that there's no toxicology report linking tranquilizer material to Suzanne. And there was no spent darts found either. The court did not find the needle sheath any more relevant than knives in a kitchen or a gun in a safe. This court gave Mr. Holbert the opportunity to address that issue, and all he said was it was a no-body homicide, and his response was that they do not know how Miss Morphew was murdered. Under those circumstances, this court found it too speculative, and that it would be error to admit to expert testimony. Then they kind of talk about Rule 403 that I had mentioned prior. Rule 401 and 403, it's about relevant evidence. Okay. So this was filed again April 5th. Now let's move on to D79. There's a lot, so I'm going to try to go through them quicker. This is to exclude irrelevant material examined or taken from the Morphew home. Let me see if I can make... Mr. Morphew requests an order excluding irrelevant evidence examined or taken from the Morphew home, including but not limited to sheets and other contents of the dryer, including a pair of Barry Morphew shorts. In court, it's kind of been mentioned that the prosecution believes that Barry Morphew had that needle sheath cap possibly in his shorts, and that's how it was found, at the very bottom of the dryer. An unfired and untested .22 caliber cartridge found on the master bedroom floor. The defense does not want that admitted into the trial. A picture frame and a surrounding area covered in a brown colored substance, but it is not blood. Some people that I've spoken to thought maybe that's a coffee stain or something. But again, that's just speculation. This is they're just wanting that whole evidence out of the trial. Stain outside of the garage area yielding negative results for blood. Stain located on exterior driveway between second and third garage doors yielding negative results of blood. Stains yellowish in color by the master bed yielding negative results for blood. a book titled, which I believe this is the Al-Anon book that she had, A Courage to Change, as well as various journals found in the home. Yellow-handled boning knife found in garage. It was found to have non-human blood on the handle and unidentifiable DNA on the blood. The defense is asking that they should prohibit not only direct evidence, but any indirect evidence, questions, comments by others, including Barry Morphew, when questioned. They're saying that their objection includes any and all prosecution statements, questions, or arguments about it, not simply evidence or testimony sought to be admitted. And they're again, stating Colorado Rules of Evidence 401, 402, 403, 404, and 608 that I have previously mentioned. This is their argument. The prosecution might be hoping that jurors infer that Mr. Morphew has bad character because of any of this evidence. It is also inadmissible because it is bad character evidence for which the prosecution gave no notice as required. Again, the defense believes the prosecution has no facts regarding the alleged murder of Suzanne. They don't even have proof that she's dead. And whether or not her husband killed her. Other things that they do not want is numerous irrelevant DNA swabs taken and tested. There was dozens of items that were tested for blood and DNA, yielding no relevant results whatsoever. It would take a very substantial amount of time during trial to go through every single item that was tested. Roger's testimony should be limited to items of evidentiary value and not include the universe of every single irrelevant item tested. The dryer contents, and including a pair of Barry's shorts. There were other people's, you got to keep in mind, there were other people's clothes and then also sheets that were inside the dryer. So, the defense is saying, how could the prosecution or investigators truly believe that this needle sheath cap came from Barry Morphew's shorts? The prosecution stated in court that the shorts in the dryer are relevant because there was photographic evidence of Barry Morphew wearing shorts that looked like those. The prosecutor apparently hopes the jury will speculate that Barry Morphew must have done something suspicious, did the load of wash to cover up a murder, or is a criminal because a pair of his shorts were in the dryer. Otherwise, there would be no reason they would be in the dryer with the rest of the household laundry. This is sheer speculation or conjecture. The shorts are unremarkable. They are a khaki pair of shorts, and Mr. Morphew owns many pairs just like them. Unless the prosecution can lay some kind of foundation that there is something unique or suspicious about these shorts and has evidence of who did the laundry load and when the load was washed and dried, the shorts are meaningless. The cartridge found on the bedroom floor. An unused cartridge was found on the bedroom floor. It's one of many bullets found in the home. It has no evidentiary significance other than to show that Barry and Suzanne own guns and ammunition, and Barry's a hunter. There is no DNA testing of this cartridge. Morphew has filed a separate motion that is relevant to this issue, and I will get to that later. Morphew has included this item in this motion in an abundance of caution because it is another example of irrelevant items taken from the Morphew home that have no place in the trial. Now to the book titled Courage to Change. It's, again, a Suzanne's Al-Anon book. It was found on a couch in a sitting room next to a Bible. Based on double or triple hearsay, according to the defense, Andy Rorick, the undersheriff for Chaffee County Sheriff's Office, testified that he expected to find Suzanne's personal journal near those items, but did not. This book is irrelevant to any material issue in the case. It is also irrelevant whether Rorick found Suzanne's personal journal or not. Admission of these items simply invites speculation and conjecture. Okay, so that is that. So they want evidence that was found in the Morphew home to be not presented in front of a jury. So after this motion, there was another motion to exclude evidence about crime shows. And I didn't get a copy of that, but according to the court's registration, like they posted just recently, actions of registry, you can see that there is a D80 motion. I just, when the clerk's office gave me all these documents, they accidentally left out this one. So, but according to the arrest affidavit, the spy pen that Suzanne used to listen in to some conversations or whatever Barry Morphew was doing in his truck, allegedly, he was listening to Forensic Files, which is a crime show, and one of the Forensic Files that he was listening to was about a girl who went missing when she went on a bike ride. And so the defense does not want that evidence introduced to the trial or into the trial at all as well. But I do not have that motion, so I cannot show you that. I'm sorry. But I know it's there. It's D80, but let's move on to D81. So this is, they want to exclude irrelevant material, including clothing found in a community dumpster. So there's a dumpster outside the Morphew property, and it's a community dumpster. And investigators took, items from there and tested it through DNA and things like that. And so there was beer bottles, camouflage clothing, and a router that they found. And these are just a few of the items that the defense does not want the juries to know about or to hear about. So they also don't want any questions and comments by others, including Morphew, about these items either. And so the dumpster is one utilized by the entire community. The law enforcement found nothing of relevance to this case in the dumpster. There were apparently some other person's camouflage clothing found in the dumpster. The clothing did not have any of Barry Morphew's DNA, hair, or other identifying physical evidence on it. A router that didn't belong or was connected to Morphew's house. The beer bottles, however, did have Morphew's DNA on them. But there's nothing relevant about Morphew drinking beer at some point prior to them being in the dumpster being relevant to this case, according to the defense. Such evidence is irrelevant because there's no proof that is connected to Suzanne Morphew's disappearance. The prosecution has no facts regarding the alleged murder. Again, they're saying they don't even have proof that she's dead. There's no theory about whether she was killed or how she was killed and how her body was disposed of without leaving a trace. So the defense does not want these items presented in front of a jury. Oh, here's the this is on the This is on the cases of interest, 11th Judicial District's Colorado page, Morphew cases of interest, where you can look at and see kind of what's been filed. So this is where I saw that there was a motion that I had missed, which was D80. Anyways, I was just going to show you guys, but sorry, there's a lot. Okay, this is April. Okay. 79. Okay, where is, I was going to show you guys D87. Maybe these aren't in order. Oh, here it is, D80. Yeah, here it is. I guess I could highlight just to show you guys. Wow, my highlighting skills is not great. So maybe I'll ask for those. And then there's also an exhibit, it looks like. Oh, no, it's to limit public access. Never mind. So it was the first thing I highlighted. Okay, so D82 now. This is, the defense doesn't want any conversations about immunity in the trial. Mr. Morphew requests an order excluding any testimony, recordings, other evidence, and or arguments regarding Barry's mentioning immunity in his conversations with law enforcement. So on March 5th, 2021, before he was arrested, it was probably approximately his 30th interview. Let me make this bigger. Sorry. Mr. Morphew voluntarily submitted to talk to law enforcement, and this is kind of the exchange. What about the immunity? Can you give me immunity if I sit and just open my life to you? This is Barry Morphew allegedly talking to law enforcement. Who would you like immunity from? Law enforcement says, I think in case somebody falsely convicts me of something. And then law enforcement replies, you won't be falsely convicted. Then Barry responds, it's happened all the time. So, and then law enforcement says, Barry, there's nothing that you can. And then, or law enforcement, sorry, says, Barry, there's nothing that you can. And then Barry responds, you guys, they got guys coming out of jail from DNA all the time. Law enforcement says, Barry, for us to put you in jail for something you didn't do doesn't get us any closer to finding out what happened. And this is a recording. Law enforcement also said, you've mentioned immunity and we've thought about it a little bit. And if we can structure some setting to make you comfortable to talk, we are happy to do that. Barry says, that's the only thing I'm worried about. I don't have anything to hide. I've been talking since day one, and everybody that is knows anybody has told me, dude, you need to shut your mouth. After this exchange, Morphew spoke with law enforcement on 4 other occasions. So the defense does not want any testimony, evidence, recordings of him talking about immunity. And this is the charge about him wanting to persuade a public servant. Yeah, attempt to influence a public servant. Sorry. I just wanted to make sure I got the charge correct. Okay. So that's motion 82. Motion 83 is they want to exclude evidence, testimony, arguments, and comments about digital forensics. So that's photographs, other evidence that regarding digital forensics. So when Morphew uses the term digital forensics, he means to include computer, telecommunication forensic, digital data extractions from computer, iPad, telephone, vehicle, or any other digital device, cell phone location, cell phone tower location, telematics from vehicles or any other device, use and or development of forensic software, forensic device from vehicles or any other device, use and or development of forensic software. Forensic device extraction, analysis, digital media, So he doesn't want any direct digital forensics evidence in the trial. Someone is asking, is the prosecution doing anything to fight back, or are they allowing defense to steamroll their case? I believe there has been a response filed that I will request next week. Again, in Thursday's video, I mentioned what the prosecution wants to eliminate from trial, and this is everything that the defense wants eliminated from the trial to be presented in front of the jury. So they pretty much don't want any digital forensics in the trial. So this is all, they're referencing other cases. Sorry if I'm going really fast. Talking about when Barry Morphew turned his phone on airplane mode. So they don't want that testimony in either. They're talking about the "I'm done" text that Suzanne sent on May 6th. It wasn't directly on Barry's phone. Agent Grusing with the FBI had to explain to the court that it was a resident image that was hidden. When an expert has to really diagnose a phone to find a resident image that was hidden, that testimony must come from an expert. Okay, now they're talking about the, in this motion, much of the evidence the prosecution might seek to introduce is patently unreliable. A good example is the officer's former belief that computer science proves that Mr. Morphew was moving around the outside of the home on May 9th, the night before Suzanne was reported missing. The affidavit for search warrant sets forth Grusing's questions to Barry posed on February 28th, 2021 about why the phone data shows that when Barry arrived home on May 9th, his phone went around the house quite a bit. Mr. Morphew surmised that he could have been shooting chipmunks, as he does that frequently around his home. Over the history of this case, this theory grew exponentially and took various forms, including a wildly speculative theory that Barry was chasing Suzanne around the property trying to kill her. It appears the prosecution has now abandoned that theory and knows there is no reliable computer science supporting it. The speculation about whether Barry was moving around his house on May 9th or May 10th was based on profoundly flawed assumptions and data that is unreliable, contrary to sound computer science, and inadmissible. And then there's a footnote. At the preliminary hearing, Agent Grusing had no answers for the fact that their data, if believed, would mean that on May 9th, Barry was running around the house through the walls of the house at approximately 36.8 miles per hour. If the phone was traveling through the walls of the house, and quite a bit faster if the phone was going around walls. Grusing constantly stated that he did not understand the calculations or data, and it would take an expert to do so. As for the allegations about Barry moving around his house on May 10th, an email provided to the defense in January 2022 reveals that law enforcement has always known that its computer science data about movement on that date is seriously flawed and cannot be relied upon. So I'm going to go to that email because it was in the exhibits. And this is the email that they're referring to. This is from Cellular Analyst Survey Team. Kevin Hoyland. And in the email, this was, again, dated June 2nd, 2020. So this is less than a month when Suzanne disappeared, and it says, let me highlight. I would be cautious in jumping right to the conclusion that he was bouncing around his property at these hours. A review of data from other nights could potentially give us more confidence if his device appears completely stationary versus that night. And then he says, just my 2 cents. Again, he's a cellular analysis survey team. So I'm going to go to the arrest affidavit where it says on May 9th, get this bigger. On May 9th, 10:17 p.m., an airplane mode off event started on Barry's phone, and the phone was then powered on at 4:32 a.m. on May 10th, 2020. That May 9th through 10th, 2020 night, approximately 210 locations for Barry's phone registered near the Morphew residence, compared to 0 to 2 locations on previous nights from May 1st through the 8th. So they did compare the movements to other nights. And that's what this email was asked, well, pretty much telling them to do so that they don't jump to conclusions. Okay, so I'm going to go back to the motion. Does that make sense? Sometimes I wish you guys could talk back to me so I can make sure that you guys are following along and understanding, or if you don't understand, I could go back. Okay, so again, they want to exclude digital forensic comments, testimony, evidence from the trial. Sorry. Okay, that was D83. Now we're going to defense's motion 84. This is to exclude recordings and irrelevant testimony of former friends. For example, Holly and Jeff Wilson, Sheila and Darren Oliver, Martin and Jean Ritter, members of the Mormon family, and others, about their suspicions and hunches. So they don't want these individuals to be able to testify or their recordings to be played for a trial. The defense says these are speculative statements or recordings, time-consuming, inadmissible suspicions and conjecture through testimony of former friends of Mr. Morphew, including, and then they list kind of who they are again. They say that Holly and Jeff Wilson were confidential human sources. They had recording devices on them when they had conversations with Morphew, which in the state of Colorado, only one party has to consent, know about the recordings. They do mention they don't want, I guess there was an accusation that Morphew touched Holly Wilson's breast inappropriately while hugging her goodbye. And Holly Wilson is a friend of Suzanne's from Indiana. They don't want the Mormon family's statements from shows such as Dr. Phil, Profiling Evil, Nancy Grace, and 48 Hours to be allowed in the trial. They also don't want testimony about others who personally interpret Mr. Morphew's mood, demeanor, or effect to mean that Mr. Morphew has a suspicious effect or that he seems to be guilty. This motion also includes a request to exclude the ridiculous accusation by Miss Wilson that Barry was parting or he touched or attempted to touch her breast area while they were hugging goodbye. I guess there's 6 hours of recorded tape recordings from conversations with Holly and Jeff Wilson, Sheila Oliver, and Darren Oliver. The defense says that these four individuals were involved in making numerous pointless attempts to obtain incriminating statements from Mr. Morphew. He did not make incriminating statements. There was no confession, no admission against interest, or no smoking gun, no probative evidence that he had anything to do with Suzanne's disappearance. The recorded interviews are lengthy, confused, muffled, and hard to hear. At one point, the tape recordings picked up someone urinating. There's hours of irrelevant material. But if the prosecution plays any part of the recordings or asks Holly Wilson or Sheila Oliver or their husbands about them, the defense says it will force Morphew to insist that the prosecution play much of the rest of them to avoid the jury being left with misleading, out of context snippets. So they don't want them to be played at all, but if they do play part of the recordings, then Morphew wants all of the recording to be played, so it doesn't mislead jurors and the information is out of context. In this court document, it's, the defense says that the Wilsons, the Olivers, the Ritters, the Mormon family despise Barry Morphew. Their disdain, suspicion, bias, and desire to see Mr. Morphew convicted will be apparent from their demeanor. Some have appeared on social media and other national media outlets. So they don't want this included in the trial either. The prosecution cannot call witnesses simply to speculate that because of that, witnesses belief that the marriage was not good. That must mean that Suzanne Morphew is deceased and that Barry Morphew must have killed her. It's an legitimate prosecutorial argument that a jury should use such speculation and conjecture to come to its own conclusion that Barry Morphew must be guilty because his friends suspect him of foul play. Again, it's the prosecution's burden of proof. So they don't want these former friends or family members of Morphew, of Suzanne's, to take the stand. They don't want recordings to be presented to the jury either. Okay, let's go on to motion 85, because there's 91 motions. This is 85, but there's 91 from the defense. They want to exclude any testimony that Barry Morphew had the capacity or personality traits to commit murder, or that Suzanne Morphew did not have the capacity or personality traits to commit suicide or leave her family. This motion is filed in order to ensure that inadmissible character evidence is not permitted in this jury trial in any form. Morphew also seeks an order that the prosecution shall affirmatively admonish its witnesses to not comment on the subject. So they don't want even witnesses to talk about his personality traits. And the defense state Colorado rules of evidence set forth with specificity what kind of opinion and reputation testimony may be testified to at trial. The credibility of a witness may be attacked or supported by evidence in the form of opinion nor reputation, but subject to these limitations. So again, they're citing Colorado law. All right. I'm going to move on to the next one. D86 is the use of the term no body homicide. So the defense doesn't want the term no body homicide in the trial at all. Mr. Morphew requests an order prohibiting the prosecution or any witness from utilizing the term no body homicide, because use of that term usurps the role of the jury, amounts to an opinion on guilt, and constitutes a comment about other cases, charges, or trials. So Trish is asking, but yet they want to talk about Suzanne's character. Is this correct? Yes, that you are correct. Mr. Morphew also seeks an order that the prosecution shall affirmatively admonish its witnesses to not comment on this subject. The term no body homicide is neither a medical nor legal term. This is not a murder case in which the medical examiner has declared that the case of death was a homicide. Indeed, there is no death certificate in this case. Thus, in this case, the prosecution must prove both that a person is deceased and that it was a homicide. Neither one of these propositions is self-evident, and both must be proven beyond a reasonable doubt. Use of the term no body homicide carries a substantial risk of unfair prejudice for no legitimate purpose. Its admission would cause an unfair trial in violation of the due process clauses of the Constitution of the state of Colorado and the United States. So again, the defense does not want the term no body homicide in the trial. Okay. Now to 87. The defense wants and prohibits, or doesn't want, it doesn't want the jury to have any reference, to hear any reference to polygraphs as investigatory tool in the case. I need some more water. Okay. So testimony about whether or not a defendant was offered a polygraph or willing to take one is not admissible. So they don't want any mention at all whether or not Barry Morphew took a polygraph, talked about a polygraph with his friends, or anything like that. They want excluded. The polygraph evidence would be inadmissible. So he's objecting to evidence, testimony, and information, regardless of whether the objection is made in a pretrial motion or at trial. He also objecting to arguments, remarks, prosecutors' questions, and all other comments on that topic. He requests this court prohibit the prosecution from making any statements, arguments, remarks, or any other comment on that topic, or including it in any questioning to any witness. So they don't even want the prosecution to ask witnesses about polygraphs. Okay, let's move on to D88. Again, these are all filed April 6th. Or some of them was, let me see, what was this one filed April 7th, 5th, 6th? Oh, April 5th and 6th. Oh. Okay, so the motion to exclude evidence, testimony, arguments, and comments about telematics. So this is data from his truck. In the last 2 decades, there have been an explosion in new technologies, such as those the prosecution seeks to rely upon at trial in this case. Many times, litigation has revealed some of the newfangled technology, fallibility in some of the newfangled technology. This type of technology is far afield from the common experience of most jurors, saying that it's sometimes so complicated that most jurors won't understand. The prosecution's proposed telematics testimony is just this type of newfangled testimony outside the common experience of jurors. It cannot be presented through lay testimony because the prosecution has not endorsed any expert in this field. Even if they had done so, the evidence would not pass Shrek scrutiny, and findings, reports, and telematics data would all be hearsay and violate the confrontation clauses. This court should exclude it. Because the prosecution's expert witnesses have been stricken, Mr. Morphew is left guessing if the prosecution will attempt to introduce the expert testimony and the evidence derived from the expert work through a lay witness or through questioning of Mr. Morphew. The prosecution may intend to introduce this untested evidence through lay witnesses, including perhaps Alex Walker, Jonathan Grusing, Ken Harris, Andy Rorick, or a multitude of other law enforcement officers that have attempted to decipher the telematics data and use it in their investigation. So when investigators would, during their investigation, they would, look to see what his telematics from his truck was versus what the phone data was saying. They would compare the two and decide, okay, that's where Barry Morphew was, or that's the location that Barry Morphew was at that specific time. They're saying they do not want any telematics to be used in the trial at all. The defense doesn't want the jurors to hear this at all. Okay, so they're saying that there were gaps in the information, but the results of the warrant generated a 626-page report that had not been analyzed either. And this is, again, during the preliminary hearing. So that was back in August, the end of August. And so I'm not sure if, probably by now before trial, they've gone through the 626-page report. But I can't confirm that for sure. So it was pretty difficult to read because it was in different sections. It had sections like when the door opened, when the door closed, when the brake lights came on, when they went off, the odometer. They were all in different, basically, sections. He's talking about the report from the truck's telematics, the Ford F350. So they're taking testimony that Johnny Grusing said on the stand, and they're using that in this motion to exclude telematics from the trial. They said Grusing was not the only witness at the preliminary hearing to give opinions and analysis based on what was called telematics or telemetrics by those names or without labeling it as such. Commander Alex Walker testified about telematics, but readily admitted he is not an expert in that field. He called it, "I am not an expert in burla or telematics. I'm going to be very cautious with that." And Commander Alex Walker is one of the lead investigators. And here's kind of what he said on August 9th. They're saying the technology used to derive the prosecution's telematic data is novel science. It is not widely or generally used in the public sphere. The prosecution's preferred evidence cannot be submitted to the jury as evidence without proper expert testimonial support to explain the technology used to derive the data and interpret the data it seeks to admit. So the defense is saying the telematic data is really complicated, and for jurors to understand it without support of an expert would be really difficult. Any questions so far? I've already talked for an hour. I'm sorry. We still have a couple more motions left, and then I can take more questions. Okay. Now to 89. Motion in limine to exclude evidence, testimony, arguments, and comments about Mr. Morphew hunting or firearms skills. So previously in other motions, you've heard that the defense has said that Morphew is a hunter. They don't want any testimony, any photographs, or other evidence, arguments regarding Morphew hunting or his hunting or firearm skills allowed in court for the trial. The defense says that Barry Morphew enjoys hunting. He has hunted numerous types of animals in his life, including elk, deer, moose, and even chipmunks. Such evidence is irrelevant to this case, other than to paint Mr. Morphew as someone who kills animals and shoots guns. Such character evidence invites jurors to speculate that he may have acted in conformity with his propensity as a gun shooter on May 10th. This is actually said quite brazenly in the arrest affidavit of Morphew. On page 126, it says, quote, Barry Morphew resorted to something he has done his entire life, hunt and control Suzanne like he had hunted and controlled animals. So they do not want any mention or photographs of Barry Morphew holding a gun, talking about hunting, or anything. They don't want witnesses to talk about Barry Morphew hunting. For a time, the prosecution made much of the theory that the fact that Barry has hunted chipmunks is evidence of guilt. In their arrest warrant and affidavit and at the preliminary hearing, law enforcement belief that computer science proves that Barry Morphew was moving a lot around the outside of his home as if he was chasing Suzanne on May 9th. There is no reliable evidence that occurred, and the emails from a computer science data expert to law enforcement indicates the data extracted from the cell phone towers does not support this theory. The prosecution should abandon this theory on the lack of any reliable forensic evidence. However, in the prosecution's response to the defense motion D69 to strike Dr. Lisa Wolf from testifying, she's the veterinarian that knows a lot about animal tranquilizers. The prosecution indicates it will continue to pursue this baseless theory in stating there's also evidence that shortly after the defendant, Barry Morphew, returned to the home, Suzanne's cell phone can be tracked running around the house as if she is being chased. Okay. The arrest affidavit for search warrant sets forth FBI agent Grusing's questions to Barry posed on February 28th about why the phone data shows that, when Barry arrived home on May 9th, his phone went around the house quite a bit. This fact is not true, and it appears the prosecution knows it is untrue and unreliable and is not introducing it. However, the prosecution may attempt to introduce Mr. Morphew's answer to Grusing's questions. Mr. Morphew submits that he could have been shooting chipmunks, as he does that frequently around his home. They're saying this theory has grown exponentially and taken various forms, including a wild speculative theory that Barry was chasing Suzanne around the property, trying to kill her. All of the speculation is based on profoundly flawed assumptions, according to the defense, and data that is unreliable, contrary to sound computer science, and inadmissible. As with the other computer science material, the prosecution did not properly endorse an expert and cannot do so now. Without several layers of expert testimony, the defense claims that neither this theory nor the assumptions and data associated with it are admissible, saying that because they don't have expert testimony to explain the digital forensics and the telematics, that this should be excluded. Hunting and his experience in hunting animals should be excluded. All evidence that Barry Morphew hunted or killed animals of any type is inadmissible. It is speculative character and propensity evidence. It is excludable because it is not relevant under Colorado 401, Colorado Rules of Evidence 401, and carries substantial risk of unfair prejudice that would overwhelm any marginable value. Talking about it would overwhelm the jurors. Sorry, I need to not read as much, I think. I can summarize. Again, the defense points out that the prosecution has no alleged murder weapon, and they have no evidence of how Miss Morphew was allegedly killed. So they don't want any photos even of Barry Morphew hunting in the trial. Someone is saying that Barry Morphew has hunting licenses in 5 states. I did not know that. Someone is saying, is there anything left that is left to prosecute him? I'm not, there's still a couple more. Let me go to the next one. D90. They want to exclude pushpin maps and diagrams or testimony about locations from cell phones. So the pushpin map, which was talked about in the preliminary hearing, was a map of, it was like an above map of the Morphew home. And then there was like push pins with notifications of when someone like Barry Morphew's cell phone was located at a certain place and a certain time. And it gave that on the bottom of the push pin, the time and date of when that marking was. So they don't want the pushpin map presented in trial at all. The exhibit and the testimony surrounding it, the defense claim isn't exact locations at the Morphew home. A particular cell phone was located at any given minute of the day or night. Again, they say, the defense says that the prosecution does not have any endorsed expert in this field. This is testimony concerning how cell phone towers operate constitute expert testimony because it involves specialized knowledge not readily accessible to any ordinary person. So they're saying that there needs to be someone that has expert about cell phone towers and how they operate, and the prosecution hasn't, according to the defense, they haven't they don't have them on the witness list, expert witness list. Okay. At the preliminary hearing, Agent Grusing had no answers for the fact that their data presented in the pushpin map, if believed, would mean that on May 9th, Barry was running around the house and through the walls of the house at approximately 36.8 miles per hour if the phone was traveling through the walls of the house, and quite a bit faster if the phone was going around the walls. Yeah, that's very confusing. Grusing constantly stated that he did not understand the calculations or data, and it would take an expert to do so. So even in the preliminary hearing, Agent Grusing said, we need to have an expert to decipher these these locations from the cell phone. This is that email again I was talking about previously, from that June 2nd, 2020 email. As an FYI, one of the challenges in determining movement with GPS readings in such a tight area is that there is a phenomenon known as static draft, wherein a stationary device can mistakenly be shown to be moving because of the number of satellites taking measurements and their corresponding locations to the stationary device. Or it could be him walking around the property, just hard to say, but I would be cautious in jumping right to the conclusion that he was bouncing around his property at these hours. A review of data from other nights could potentially give us more confidence if his device appears completely stationary versus that night. And I showed the arrest affidavit where it mentioned that that's the email. And then this is the arrest affidavit where they did look at days prior, May 1st through May 8th, where his phone location was 0 to 2 locations on nights of May 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th. And on May 9th through the 10th, there was 210 locations. Okay. I showed you that. This is motion 91. Okay. This is to prohibit improper, unconstitutional comments, questions, and statements and arguments. So the defense wants, this is the one. Okay, yeah, this is the puzzle analogy. So I know you've probably seen some interviews with DA Linda Stanley, where she talks about how, in cases with no body homicides, there's puzzle pieces talking about evidence, and you have to put the puzzle pieces together. They do not want the prosecution to use puzzle analogies or any other use of iconic images in the trial when they talk to the jurors and they explain this case. They don't want any type of iconic images or puzzle analogy. Prosecutors cannot invoke iconic images because these invite the jury to jump to a conclusion about the defendant's guilt. Like what I was saying, the prosecution displays an incomplete puzzle, and that they have to put the puzzle pieces together. Oh, someone is suggesting that the prosecution should do an animation for jury of Barry Morphew's vehicle movements. That's interesting. Again, this is the puzzle analogy. Someone's asking about Judge Ramsey Lama's experience. The defense doesn't want fill in the blanks argument, or they're saying those are also equally improper to be used in the trial. Okay. I'm going to answer that question about Judge Ramsey Lama. He was appointed to the district court bench in January of 2016. He hears criminal, civil, domestic relations, and juvenile cases. Prior to his appointment, he was a Colorado practitioner at the law office of Ramsey Lama, LLC. His practice focuses on criminal defense. Prior to forming his own firm, Lama worked for the office of the Colorado State Public Defender in its Salida and Grand Junction offices. Lama earned his undergraduate degree in 2004, and in 2008, he got his Juris Doctor from Cleveland Marshall College of Law. Aquinas College in 2004. I don't know where that is. So he's been a judge for quite a while for the district court. 2016, excuse me. So that's 6 years. Okay, let me go back to what we were talking about. Okay. Okay. The prosecution also doesn't want, the defense doesn't want the prosecution to talk or make comment on the defendant's right to remain silent, innovation of that right, failure to make a statement or any similar statement or comment. This proscription should apply to any person who is or was a defendant or potential defendant. Yeah, remain silent or request for an attorney. Decline to testify, withholding consent to search, nervousness when asked for consent. Although the defense is not aware of Mr. Morphew ever withholding consent to search, the prosecution may claim he was nervous when he consented. This reasoning is equally applicable to use of a defendant's refusal to consent to entry or search. But Morphew, he talked to investigators. He was pretty open with them. 30 interviews. someone says, Sixth Sense, Amelia says, I go hunting. I don't murder people. I don't understand the relevance to this murder case unless a specific hunting firearm was proven to be used in this crime. People's right to fair trial, or both sides' right to a fair trial. Is the defense okay with the daughters testifying? I'm not sure if the daughters are going to testify. I haven't seen their witness list yet. Putting on a defense is a tantamount to minimizing, denying, or blaming others. This court should the prosecutor to refrain from stating or implying that when the defendant puts on a defense, he is denying or blaming others or minimizing, juxtaposing this argument against the jury instructions that will be given in the case. So I think the defense is claiming when every time he said, I don't recall, this is what the defense is referring to. They don't want that in. Okay. Any questions? I'm about. Oh, okay. I can talk about that next. Because of the prosecution's evidence, this should preclude the prosecution from stating that after the close of evidence. Okay. Okay. The defense also doesn't want the prosecution to point at Mr. Morphew during the trial, as well as refer to him as that man, that defendant, this defendant, killer, and other such derogatory terms. They only want him to be called by Mr. Morphew. And they don't want him to be called Morphew. They would prefer the prosecution referring him as Mr. Morphew. They also don't want the prosecution to say Mr. Morphew or any other witnesses was lying. It's improper for a lawyer to use any form of the word lie in characterizing for a jury a witness's testimony or his truthfulness. They also do not want the prosecution to characterize Mr. Morphew as, or any defense counsel as, oh, that was a nice story, a whole rainbow of explanations, a lie, garbage, a tall tale, ridiculous, or similar phrases. Again, this is motions from the defense, Barry Morphew's attorneys. So I missed a couple in this motion. I'm going back to my notes a little bit. They don't want the prosecution to fault the defense for not investigating more, calling witnesses, conducting scientific testing, or taking other steps to prove his innocence, claiming Morphew has lost the presumption of innocence because of the prosecution's evidence, calling Morphew names or pointing at him. I talked about. Defense wants the court to preclude the prosecution from making a golden rule argument, putting the jurors or the community in Suzanne's shoe, or seeing the evidence through her eyes or her point of view. Defense does not want the prosecutors to put pressure jurors to, quote, do justice for a victim. It's a channeling argument, speaking to the juror, or they do not want the prosecution do the channeling argument, speaking to the jurors in the first person or her family speaking, trivializing reasonable doubt or inverting the burden, using analogies that have the effect of lowering the burden of proof, urging the jurors to convict in order to deter crimes, send a message, or protect the community or other illegitimate purposes. So this is the golden rule argument. So talking to the jurors and saying, see the evidence through her eyes or her point of view. And then arguing that the jurors should be, doing justice for Suzanne. The channeling argument. So in the channeling technique, the prosecutor speaks to the jurors in the first person as if he or she was the victim or her family speaking. Teresa Gilbert says, wow, a lot of demands. Let's remember who the real victim is. Say her name, Suzanne Morphew. Yeah, this is the trivializing. Yeah, so the defense, Barry Morphew's attorneys, wants the court to preclude the prosecution from trivializing the beyond a reasonable doubt standard by comparing it to everyday events or from actions and one does not refrain from acting. Again, with the puzzle analogy. So they're citing other cases. Telling jurors to think of commonplace everyday events such as the likelihood of earthquakes or car crashes. Okay. Urging the jurors to convict in order to deter crime, send a message, or protect the community or other illegitimate purposes. Ozzy says there will be objections every 2 seconds. I hope the judge will deny all this or the trial will be a total nightmare. Thank you guys for engaging in the conversation. There's just a lot of motions in limine and things that the defense do not want in the trial. And again, if you missed Thursday's video, I talked about what the state and the prosecution wants to be eliminated, what evidence and things that they want out of the trial. Okay, so I'm going to take you to an exhibit, which is the discovery log. And it has kind of, let me look at it in detail, bigger. This was filed April 6th. So this is what the defense has as the discovery log. This is this kind of what they say they have. So you can look through this and see anything that stands out to you or something you didn't know. Foosa's lake photos, map of Garfield Mine, just miscellaneous screenshots. Recorded calls, interviews with Barry Morphew, pen recordings, dispatch recordings, trail cams, interviews with various individuals, family members, friends of Suzanne's. Looks like Cody Cox did a polygraph. Let me know if I'm going too fast through these. Oh, thank you. I'm wondering if these are surveillance video from all these businesses, or what the 1ARR mean. Oh, it says security trail cam files. So yeah, these are, looks like video. Safeway, Surf Hotel, Monarch Lodge, Shell Station. I mean, there's a lot of video surveillance in this case. Barry's iPhone. Credit unit phone. Bobcat GPS records. Oh, see, these are warrants that they had to have to get these. AT&T tower dump records. Barry T-Mobile return. Barry's Verizon. SIM card from Bobcat. George Davis's records. Verizon records. Libler's, Jeff Libler's Verizon return. Morgan Gentile's Verizon records. Shoshona AT&T records. Suzanne Morphew's video records. Miles Harvey, Macy Morphew, Mallory Morphew. A lot of phone data. Snapchat records. Wow. Facebook records. Jeff Smith Facebook records. I wonder who that is. Morgan Gentile Facebook. All the daughters' Facebook records. Twitter. All right, you guys can read the rest. I think that's the end of it. I think this is just showing how big the file is. I don't know why it's upside down. Okay. All right, so that's all of the documents I had to show you guys. So I am ready for some questions if you have any. Let me look to see. Did the prosecution ever say that there is proof Barry was having an affair, or was it only Suzanne? Right now, it's only Suzanne. There hasn't been any talk in court at all, or any documents that I've read that, said that Barry Morphew had an affair. Thank you for that question, Terry. Where is Suzanne missing cancer comfort medication? She is just refilled. Controlled substance meds? It's a great question, Teresa. I believe that the defense wants to call a medical examiner or medical expert to talk about medications and what they do to people. And I'm not sure exactly when those medications were last filled, though. Hi from UK. Hi. Is it LA? Ellie? Hello. Okay. Did they have a cadaver dogs go through the house? I believe they did. That's a great question because we haven't heard about cadaver dogs necessarily. We've only heard about scent dogs in court. And so in the arrest affidavit, I believe it does talk about some cadaver dogs that made some hits in and around Barry Morphew's bobcat in the trailer that was that was next to the bobcat that was parked there outside of the Morphew home. And I believe there was 3 separate dogs, cadaver dogs. Does anyone know if the public petition to recuse Judge Lama was considered for change? I don't know. I wasn't, oh, are you talking about the change.org petition? Yeah, I'm not sure about that one. Any other questions, guys? And if you missed earlier, once I publish this, after it's live, you can go back and watch the previous motions. Where's Suzanne's towel, her cell phone, her journal? Did they find her bathing suit? So many questions and no answers. In my honest opinion, he dumped evidence in Broomfield. This is from Judy Johnson. Judy, I believe they haven't found her cell phone. Investigators believe that there was journal remnants in the Morphew's fireplace. And I believe they have not found the brown towel that Suzanne was laying on in her last proof of life photo. And her bathing suit, I'm not sure exactly if that was mentioned at all in court either. L. Anders, even though they don't have Suzanne's phone, can't they access records from the provider? Yes, they have requested records from the provider. I'm going to share my screen once more to show you kind of those photos, or the photo of the last proof of life of Suzanne. Sorry. All right. Nope, that's not what I want to show. Sorry. Okay. This is the last proof of life photo that we were referring to. Oh, sorry. I forgot you guys are seeing the screen I'm seeing. Okay. So that's the brown towel that that person was wondering about if that has been found or not. And it has not been. There's her bike that was recovered. There's the bicycle helmet. Were any landfill searches done in Denver and Broomfield? That's a great question. That has not been brought up, but it's a good question. Here's that note in the helmet with Barry Morphew's information and the daughter's information. Here's the, I don't know if you can see my cursor. That's I believe, where the helmet was found, and the road. I'm not exactly sure from what this angle is, if the road is, I think the road is up here. And kind of here's a better, this is like a pinpoint map that the defense wants to exclude from the trial. Here's the Morphew residence, and then in comparison to where the bike was, and in comparison to where the helmet was. And then some photos of Suzanne on Methodist mountain biking. She would always have her camel pack and her helmet and sunglasses on. Obviously, she had her phone to take the photo. And a lot of these pictures, you can see that she has earbuds in, listening to music. Nancy Schmidt is asking, when will we know if the judge approves these motions? So the judge, Barry Morphew's next court appearance is Tuesday, but that's a pretrial readiness conference. And then April 28th is when, or April 29th is when Barry Morphew will be once again in court for a Shrek hearing, and some expert witnesses might be also struck from the trial. Just depends on what the judge decides. But Sally, I will get to your, did they cast the footprint on the Bobcat? I will get to that question in a bit. Anyways, so as far as kind of what's going to happen next, obviously the judge just got a rule on these motions, and it has to be before the end of the month. So I'm not sure if that's going to be at the pretrial readiness conference, or if he's going to wait until the Shrek hearing scheduled for April 29th. Or it could also be just in a written order that he just puts, goes through the court system, and you can see it on the cases of interest page. So about the cast on the, there's alleged barefoot footprint on the Bobcat's bucket that one investigator said he saw, but no photographs, and I don't believe any casts were made of that, unless they did it and they didn't put it in the arrest affidavit. But as far as I know, I don't believe that they made a cast for that. So people have asked me, will I be at the trial every single day? No, I will not be there every single day. I'm sorry. I do have to cover other news of the day for my station. And so, will I be there for the big moments, like opening and closing statements, and when Jeff Libler or Sheila Oliver or some of the family members testify? I plan on it. And so I do want you guys to be aware that it is a long trial. It's set for, I think, 5 weeks. And so I cannot be there every single day, but I will try to be there as much as I can. And again, we right now can't have our computers and we can't live tweet. So the best way, that's another reason why I decided to kind of start doing this more often, is so that I can try to inform you guys as best I can through Facebook, Twitter, and YouTube as well. So anyways, I'll take a couple more questions, but then I do have to get off and go to work, physically go to work. So the trial is set to begin April 28th. That's when the jurors will be called, and they'll decide the jurors. The potential jurors will then, they'll like dwindle it down, and then opening statements will follow after they decide the jury. Any questions, guys? Let me see if I can look at some of the comments. Cameras in the courtroom. No, cameras are not allowed in the courtroom as of right now. What fingerprints are you talking about, Rhonda? Can you clarify your question? Someone is asking. That will, Chris, great question. That will ultimately be up to Barry Morphew whether or not he wants to testify in his trial. He does have a right to. Oh, the glove box. Okay. The swab. So that's another decision that the judge will have to make, whether or not, that's something that the state does not want in the trial is the CODIS matches, because all of those 3 CODIS matches have been excluded. They followed all the leads to each one of those, the Tempe, the Phoenix, the Chicago one, and it's not connected to this case. And so the state has requested for the CODIS hit match, the CODIS matches to not be included in the trial. We don't know yet if that if the judge is ruling yet. Will Linda Stanley be there? Judy, are you asking about the trial? I believe she'll be there for the trial, yes. Will Fox 21 get the court transcripts? Is that what they're saying? For which day, Plunder? I'm starting to read some of the other comments, even though they're not on there. Let me answer a couple more questions. Again, I spoke mostly about what the defense is wanting to exclude from the trial. Matt Block, will you be doing lives as we cannot watch here in the UK on Fox 21 News? I will try as best I can, depending on timing, when and I have to obviously do TV broadcast as soon as I get out of the courtroom. And then I'll have to tape some things for the evening shows. And then as soon as I can, I'll try to get on either YouTube or Facebook or Twitter, just to kind of go over my notes and kind of give you guys as much information as possible from what's going on in the trial. Yeah, Plunder, what transcripts are you asking? As far as the days that we miss, Fox 21 misses, the transcripts will be very, very expensive if I ask for the entire trial or even a day of the trial. Yeah, any of the court transcripts for the 5-week trial. Just depends as far as what goes on, and if I miss a day and I'm not there, it just really depends. Sorry, Plunder, I can't fully answer that question. Could jury convict of second-degree murder if they don't feel first-degree was proven beyond doubt? Great question. I don't believe. I think it's just first-degree murder. That's what he's been charged with. So I don't believe. I don't believe they can drop the charges down to second degree. That's a good question for a lawyer, and I'm not a lawyer. I don't have a law degree, so please do not take what I just said to heart. I will ask a lawyer. How about this? I'll ask a lawyer and have that answer either on this YouTube comments. I can put that in, or I can tweet about it. How about that? How do they get to keep cameras out of the courtroom? So it's up to the judge. I mean, it's really the judge's discretion. And so right now, this judge doesn't want distractions, not even computers in the where people watch. And so we can't have our cell phones. So he doesn't want anything that might hinder the trial and the outcome of the trial. I'm going to take one more question. Yeah, there were deleted texts and even calls from Barry Morphew before he allegedly handed over his phone to investigators. And that's something they don't, the prosecution, or not the prosecution, sorry, the defense does not want digital forensics in the trial. And that would be those 300 texts as well. Okay, guys, thank you so much for watching. I've got to get to work now at Fox 21. If you have further questions, I will try to answer them in the comment section on YouTube later on in the next couple of days. Again, if you missed my YouTube video from Thursday, please go back and watch. I talked about the CODIS matches and extensive with court documents like police reports and stuff. And please go back and watch that, as well as what the prosecution wants excluded from the trial. So if you missed Thursday's video, go back and watch that one. And again, thank you so much for watching today on a Saturday. And again, we are about a couple weeks away from Barry Morphew's murder trial. So I will try to give as many updates to the case as I can via Facebook, Twitter, and YouTube. Have a great rest of your weekend. Bye-bye.